Mr. Austin, to the Tyler Hatton. Correct.
Yes.
Yes, Your Honor.
We're on the record in the matter of the people of the state of Michigan versus Tyler James Hatton, file number 1-00436 FY. Appearance for the record.
Thank you, Your Honor, and good morning. Jared Austin appearing on behalf of Mr. Hatton. He appears with us today remotely from the county jail.
Mr. Hatton, can you hear us clearly?
Yes, Your Honor.
Okay. Do we get a pre-sentence report? Let's see.
I received one, Your Honor.
I see one from Mr. Hosky. Is that the one you have dated for April 17th?
Correct, Your Honor, and there was also, subsequent to that, I received what appeared to be, I think, an intake form that was filled out.
Correct. I do have the intake form that was completed. It looks like because of his incarceration in Eaton County, probation was not able to meet with him. So I'll allow you to make allocation at this time.
Yes, Your Honor, thank you. Obviously, Mr. Hatton has problem with controlled substances. I think that has been the genesis of most, if not all of his criminal history. What I can tell the court, Your Honor, is that he is currently now on probation with the Eaton County Circuit Court. And also next week, he is set to be sentenced here into our drug court program. And the plan is for him to be transferred shortly thereafter to residential treatment at Bear River, which Mr. Hatton both needs and wants. So he's going to be getting the help that he needs, I believe, between those two counties, particularly our drug court program, Your Honor. He has served approximately 11 months in this matter on a 1-year sentence. Given that, Your Honor, and given that he's going to get the supervision and the treatment, the help that he needs elsewhere, I think a sentence of time served in this matter would be appropriate, and that's what I would ask the court to sentence Mr. Hatton to. Thank you.
Thank you. I think that's the same position that the probation department has taken. States here that he served 330 days in Ingham County Jail. So we will give him credit time served, and that'll allow him to focus on his probation and potential drug court and the other file. Do you have any questions today, Mr. Hatton?
No, Your Honor.
Any additional matters from representative?
Nothing further on behalf of Mr. Hatton, Your Honor.
Okay, you're all set. Thank you.
Have a good day.
Same to you.
Thank you, Mr.
Thank you.
Austin.
Good luck, Mr. Hatton.
Thank you, sir.
Dana Campbell. You just need the prosecutor.
Good morning, Your Honor.
Good morning, how are you?
Good, and yourself?
Pretty good, thank you. Just waiting for the prosecutor. We're on the record in the matter of the people of the state of Michigan versus Dana Ray Campbell, file number 09-04936, council appearance.
Brian Ring on behalf of the people.
Conrad Vincent on behalf of the defendant in this matter, Dana Campbell. To my right, Ms. Campbell appearing, Your Honor.
How are you, Ms. Campbell?
Thank you for asking.
No problem. Today was the date and the time that was set for a preliminary examination. However, I have a note here that our last court date, the discovery was still pending, and we indicated we would treat today as a probable cause conference. I think we set the examination for June 1st. Is that correct?
That is correct, Your Honor.
Okay. Is discovery still pending, or are there any issues that we need to address right now?
Your Honor, I was actually able to speak with the prosecutor, and we do have a resolution in this matter.
He's doing.
She was gonna plead to an added count. Sorry, I don't have the complaint up right on me.
It was an added count of larceny under 200.
I didn't know the number on that count. It was a-
I don't have the code on that.
It would be an added count 5 of larceny less than 200. The PAT code. is- I had it right. I had it. That would be under MCL 750.3565. And that's a 93-day and or $500 and or 3 times the value of the property stolen, whichever is greater. And the people would make a sentencing recommendation of fines and costs only with restitution.
How does your client want to proceed?
Your Honor, my client is prepared to plead guilty under the terms that the prosecutor has outlined for the court. I don't know if the court would intend on following that recommendation or if a cause would be appropriate in the matter. See if the court would follow such a recommendation.
Okay, do you have a sheet
I do not, because I can make that real quick.
and advice of rights? And
May I approach, Your Honor?
yeah.
Thank you.
Thank you.
Thank you. I didn't know if the court would entertain a cost conference on the people's recommendation of fines and costs.
Just a moment,
Oh, okay, I'm sorry.
Yeah.
This matter is from 2009. Correct.
That is
Correct, Judge.
Your Honor.
I don't think it's meaningful to entertain judicial oversight or jail time in this matter. But you still like to have a cops, you can do that. I find some cost seems appropriate.
Thank you, Your Honor.
Okay, and then you want to accept the offer, which is for you to plead guilty to an added count of larceny under $200. That's a misdemeanor, maximum penalty 93 days in jail and or $500 in fine and or 3 times the amount of value, whichever is greater.
Yes, Your Honor.
Okay. Is there restitution?
There is, Your Honor. I'm working on that sheet right.
They understand there's restitution that would need to be paid.
Yes, Your Honor.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
I do.
You can put your hand down. Okay. Ms. Campbell, before you can accept the offer, you have to give up certain rights. One of those rights is your right to proceed to a trial. You have the right to have a jury trial. Do you understand that?
Yes, Your Honor.
You have the right to the presumption of innocence. So you're innocent until the prosecution can prove you guilty at trial, and they do that by proving each element of the charge being brought against you beyond a reasonable doubt. Are you willing to waive those rights today?
Yes, Your Honor.
You would also have to give up your right to remain silent at a trial and not have sounds used against you. You're going to be giving up your right to cross-examine or confront any of the witnesses that the prosecution intends to call. You're going to give up your right to call your own witnesses or present evidence that you believe would further a defense to the charge. You understand that?
Yes, Your Honor.
Anybody threatening you or making any promises to you to get you to waive your rights today?
No, Your Honor.
Are you currently on probation or parole?
No, Your Honor.
Do you understand that a guilty plea could result in a conviction that you may need to report to your current employer?
Yes, Your Honor.
You also may need to report a conviction on a future job application. You recognize that?
Yes, Your Honor.
And a conviction could have impact on any travel or immigration status you may be seeking, such as you may want to go visit Canada. You understand that?
Yes, Your Honor.
Okay, you still want to waive your rights and enter a guilty plea, understanding the rights that you're giving up?
Yes, Your Honor.
Okay, lastly, are you entering a guilty plea because you believe you're guilty?
Yes, Your Honor.
As to the added count 5 of larceny less than 200, how do you plead?
Guilty.
Counsel, can on factual basis.
Yes, Your Honor. I will be putting a factual basis for the initial charges. So, ma'am, you had written checks, is that correct?
Yes.
And those checks were written in someone else's name?
Yes.
You attempted to cash those checks
Yes.
and you attempted to keep that money, is that correct?
Yes, I did.
Okay, and you knew that those were not your checks, is that correct?
Yes.
And you knew that those were not written by someone to you, but rather you wrote that with the intent to defraud and receive money from those checks, is that right?
Yes, I did.
Yeah, I believe that's a sufficient factual basis.
Any questions, Mr. Ray?
No, thank you, Your Honor.
Court is satisfied with the factual basis. I'll accept your plea, find your plea to be made freely, voluntarily, and intelligently. Restitution amount.
I do, Judge. It's $5,300.
What have you been doing since 2009, ma'am?
What have I been doing?
Yes.
I've been working and I have a family and I've been giving myself, I have a great relationship with my family over the years. I stopped using I have a wonderful relationship with the Lord. In the past 6 years, I've had a child in my care since he's 5 days old. So it's been like starting over. I have my daughter with me today. Very family oriented.
I pulled your criminal history before I responded to your attorney about the needs for any cause. And it looks like there hadn't been any interaction or engagement on your behalf with the criminal justice system since about 2008. And then this incident, which I don't know why. Is this a reissue?
I don't know what the reason for the such a late issue, Judge.
Yeah, I'm not sure why, but it popped up this many years later. Nonetheless, it's apparent just by the mere nature of the pattern of your criminal history that there was something that changed within you.
Yes, Your Honor.
And so that's a positive. So I'm
Thank
glad
you.
to see that you have found a relationship with the Lord and that you have a family oriented and that you're doing what you need to do so that you can be a productive contributing member of society. With that being said, the sentence of the court is restitution in the amount of $5,300 to be paid to the victim in this matter. Is this the current address of the victim?
I am 100% unsure of that, Judge. I spoke to her, I spoke to the victim's son, who
Okay.
is the victim's guardian,
Got it.
and
Okay.
the victim's son lives in Illinois. I could readdress that to him if need be. But I'm not 100% sure that that's. the
Okay,
correct
I just
address.
want to make sure we get this to the right person after these many years.
I can take that sheet back and then resubmit.
Yeah, if you
it.
want to submit that after you confirm, that's perfectly fine.
May I approach, Judge?
You may. As to fines and costs, there's a $75 crime victim rights fee that per statute I must assess, plus a $50 state minimum cost. I'm gonna waive discretionary fines and costs. And you'll be making monthly payments on that, is that correct, ma'am?
Yes, Your Honor.
I mean, if you're prepared to pay it all at once, that's your business.
Yes, Your Honor.
Oh, you're prepared to pay it all?
Yes, Your Honor.
Okay, you can do that. Okay, the total is $5,425. You're gonna pay that today?
Yes, Your Honor. I'm sorry.
Are you
She
sure?
helps me with my banking. Yes, Your
Oh,
Honor.
okay.
Your Honor, I just wanted to say, I believe that the victim was made whole. It's probably the bank. I think it's the
Yes.
bank that she owes the
Okay,
money.
I'll double check it and make sure that I get it properly.
Very good. Okay. Any additional matters for the record?
Nothing on behalf of people. Thank you, Your Honor.
Thank you, Your Honor.
Thank you. You're all set and good luck to you, ma'am.
Thank you so much, Your Honor. Have a nice day.
Thank you.
I'll call you back.
All right.
Yeah, thank you.
Thank you very much, Your Honor.
Thank
Have a
you.
nice
Have a
day.
good one. We're on the record in the matter of the people of the state of Michigan versus Joseph Bartha. File number 22-02486. Council appearance, please.
Brian Ring on behalf of the people.
And Luke Goodrich from the Public Defender's Office, here to represent Mr. Bartha.
How are you, Mr. Bartha and Mr. Goodrich?
Very well today. How are you?
I'm doing well. Last Friday. There's a date and a time that was set for a preliminary examination. I do have a nollie here. So the necessary witnesses fail to appear. The people are moving to dismiss without prejudice. Do you understand what that means, sir?
Yes.
Okay, so the case will be dismissed today, but the people are not prohibited from bringing this case back if they re-engage with the necessary witness. Do you understand that?
Yes.
Do you have any questions at this time for the court?
This court has placed a hold on my license and suspension. Secretary of State, would you be able to remove that suspension? Secretary of State has said it's a court matter.
Relative to this case?
Yes.
Reason, Ms. Remy? For this case? What's that called? That's in JS. Failure to comply.
If I may
You and I
comment.
believe you missed the arraignment, the original arraignment that went out where they sent the notice of the
Yeah.
arraignment. You didn't get it.
Gotcha.
They sent it to a previous address and I haven't lived at for years. And when I failed to receive the information, they sent it that way.
I'll waive it and have that suspension removed. Any additional matters for the record?
Nothing on behalf of the people. Thank you, Your Honor.
None from the defense, Your Honor. Thank you.
Good luck to you, sir.
Thank you very much, ma'am. Have a good day.
Same to you. Mr. Cassidy? We're on the record in the matter of the people of the state of Michigan versus Sean Thomas Cassidy. File number is 23-01066. Apply counsel appearance.
Brian Ring on behalf of the people.
And Luke Goodrich from the Public Defender's Office here to represent Mr. Cass. Your Honor, I got an email late last night about after 10 o'clock from Mr. Cassidy's girlfriend that he had to go to the hospital for some trauma that they didn't know if it was going to require immediate surgery. I spoke with her on the phone this morning. She said that they were working on trying to get him a ride here, but they didn't know if they were be able to. We would ask the court to adjourn this hearing and reschedule a new preliminary exam date out a few weeks to see if we can get Mr. Cassidy.
His girlfriend contacted and said he needed transferred to the hospital.
Yes, last night. And then I spoke with her on the phone this morning. She said that they didn't go into immediate surgery, but they didn't know if they would be
I'm
able
gonna need
to.
a notice from the doctor or something. He had a lot of girlfriend calls. Doesn't really work well with me. I'm not finding good cause to wait for 21 days without it. Well, I know you don't even have a girlfriend.
Is the court issuing a warrant then at this time, or?
I'll hold it for 48 hours. So we
48
can get in
hours.
contact. and
Okay.
tell him We need some proof that he's in the hospital.
All right.
Okay. If I can get some proof that he's in the hospital, then I'll find good cause to adjourn, even if she has to put him on the phone with you. I'm not gonna speak to a girlfriend now. Or I'm not gonna take the word of a girlfriend. Supposedly, that he can't be at court. Rule that one. Is that all you have for today?
No, I also have Gabriel Williams, which I believe is going to be a waiver.
Okay, well, on the record in the matter of the people of the state of Michigan versus Gabriel Michael Williams, file number 23-01028.
Brian Ring on behalf of the people.
And Luke Goodrich from the Public Defender's Office here to represent Mr. Williams, who's standing to my right today.
Let's see, how are you, Mr. Williams? I'm doing very well, thank you. You have a very powerful name. You know that, don't you?
Yes, ma'am.
What does your name mean?
Huh?
What does your name mean, do you know?
My mom tells me I sometimes be having to recollect on it. But yeah, she tells me it's very powerful.
Gabriel and Michael, both.
Yeah, good angels. Yeah.
Yeah, one's Archangel One's a messenger of God.
Mhm.
Strong name. Means you have some purpose. And I don't think it has anything to do with you being before the court.
Yes, ma'am.
Do you recognize that?
Yes, ma'am.
Okay. I'll leave that to you to figure out, okay? Nonetheless, there was a date and a time that was set for your preliminary examination. I do have a completed bind over form, so this matter is being waived to circuit court, is that correct?
Yes, ma'am.
Yes, that's correct, Your Honor.
Was there an offer?
There was no offer, Your Honor.
Okay, Mr. Williams, you understand that you have the right to have a preliminary examination here in the district court. You understand that the purpose of the preliminary examination is to require the prosecution put forth evidence to establish that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. And are you willing to unconditionally waive that examination right today?
Yes, ma'am.
So that means this matter will be brought over to the circuit court. There will be no requirement met by the prosecution to establish probable cause. You cannot come back later and decide that you wish you had had your preliminary examination. You recognize that?
Yes, ma'am.
Okay, anybody threatening you to get you to waive your examination?
No, ma'am.
Any promises being made to you in exchange for you waiving your examination?
No, ma'am.
Okay, you sign this document here, sir?
Yes, ma'am.
Okay, find your waiver to be made freely and voluntarily. I'll bind the matter over to the circuit court. Your bind over date is May 3rd. You do not need to appear in court on May 3rd. That's the date that the circuit court will get the file from the district court, okay? Your next court date will be in circuit court, but it'll be a pre-trial. You and Mr. Goodrich will get notice of that date in the mail, okay?
Can I possibly change my address?
I was just about to confirm the address with you, because on our paperwork, we had unknown, and then it was 300 Western Ave, so where are you now?
1127 West Avenue.
Is there an apartment or is that a house? Okay. Is your phone number the same?
It
313 number?
is, but right now the police have evidence, so I don't have
So,
to wait to that phone.
well, we'll update your address. Make sure you'll get your notices in the mail then.
Okay.
Do you have any other questions?
No, ma'am.
Bond was set at 2,000 personal recognizance that will continue. Any additional matters for the record, counsel?
Just briefly, Your Honor, that I will be reaching out to LPD to see when that phone could potentially be released from evidence. And I'll be in contact with Mr. Goodrich to let him know any updates that I have.
We appreciate that. Your Honor. Thank you.
Thank you. You're all set.
Thank you. Have a good day.
Thank you.
right
I see
now
Carter
running,
on Juarez.
running an exam. And this house will pay for one of those swabs too, and I think they're still trying to work something out.
Let's see. Ex parte motion to withdraw.
Oh, that's for Carter.
He withdrew. Mr. Rossi withdrew a long time ago. Someone needs to get that together. I don't know why it says that. Okay, so we're just waiting for Mr. Carter on these three. On the record in the matter, the people of the state of Michigan versus Craig Wells Tanner, file number 21-01608, FY, council appearance.
Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Well, Your Honor, Edward Hess on behalf of Mr. Wells Tanner. Mr. Wells Tanner stands to my right at the council table.
Okay, how are you, Mr. Hess and Mr. Wells Tanner?
Well, it's my thank you. How are you?
I'm great. How you doing?
I'm doing well, thank you. How are you, Mr. Pfeiffer?
Doing well, Your Honor.
Okay, today was the date and the time that was set for preliminary examination and a K-53 contempt. Any preliminary matters before we proceed?
Your Honor, people prepared to proceed on the preliminary examination. Has been Officer Aaron Bush. Request for bind over at the end of the examination today. The people are unable to proceed on the PA-53, and at this time would ask that be dismissed.
We never actually received the K-53. I don't see it in the file. So I don't know what it was.
That was the allegations that the victim conveyed to me the day before the PCC. I brought it to the court's attention, so I think we set it on the books.
Okay, sounds good.
I don't have necessary witnesses for that, so people would ask that just be dismissed.
We'll dismiss the K-53. Any other preliminary matters before we proceed?
Not from people.
Nothing from the defense.
You call your witness.
Yes, sir. People call Officer Aaron Bush. On the flash drive, people posted it one. It's just a batch of the photos. Just in color. It's the straight photo PDF that was sent to
Yeah,
us.
believe it or not, I was having terrible color printing issues too. I would only print it out in red, black. So I feel your
That's
pain.
one more color than ours did. so.
Right. Yes, that's fine. Thank you.
Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Swear.
You can have a seat, officer. Please state your first and last name and spell both.
Aaron Bush, AARONBUSH.
Please proceed, counsel.
Thank you, Your Honor. Good morning, Mr. Bush. Where are you currently employed?
Lansing Police Department.
And what's your role there?
As of right now, I'm assigned to the Violent Crime Initiative.
Are you an officer?
Yes.
So Officer Bush, were you working that capacity on, or as capacity of a police officer on March 9th, 2021?
Yes, I was a patrol officer.
And how long have you worked with the Lansing Police Department? 4 years. Now, on that day, were you dispatched out to 706 West Saginaw, apartment 1? Is that in Lansing?
Yeah.
Is that in Inman County?
Yes.
And why did you go out to that location?
A woman named Sarah Johnson had called. Originally, she was calling about damage to her property. So I went there and she ended up describing that as well as a domestic violence situation to me.
So at that location, you made contact with Sierra Johnson?
Yes.
And as a result, talking with her, you determined a domestic violence incident taking place?
Yes.
You determine roughly how much time had passed between the assault and when you were talking with her?
I remember I was dispatched around 9 p.m. Dispatch received the call a little after 8 p.m. And when she called, she told them there was a half-hour delay between when it happened and when she called. So it would have happened approximately 7:45. Yeah.
And you talked to her around 9.
Yes.
Now, did you observe any damage to Ms. Johnson's property?
When I first showed up, I saw damage to the vehicle outside.
And then, as a result of investigating this matter, did you observe any other damage inside of her residence?
The television in her bedroom was also damaged.
Now, were photographs taken of these? Your Honor, at this time, I would seek to provide to the officers Mark Field's proposed Exhibit 1. It is on the flash drive, if I could have the HDMI cable. For the record, there are photographs, there was just issues printing them off in a way that.
That isn't one you can log into Zoom. Just share your screen.
Good idea.
Just for Mr. Rain's advice, make sure you're muted. Otherwise, we're all gonna get the piercing feedback.
Host as disabled participant sharing.
You know, we had a situation one time. Someone kept logging in trying to share their screen, and I disabled it then, and then it still was letting him share his screen. What did I do?
Yeah.
Did it? These commands are doing in the meantime. We're gonna make Mr. Pfeiffer host.
Dangerous.
Try to figure out what I did. Finish that.
There we are.
Certainly some stuff.
I appreciate the technical assistance, Your Honor.
No problem.
So this set of photographs has been marked as People's Proposed Exhibit 1. It was already shown to defense before the examination and testimony began. Officer Bush, do you recognize this photograph?
Yes, that's the vehicle Sierra Johnson advised me belonged to her.
And that's the vehicle you observed the damage from?
Yes.
Moving on to the next photograph. You recognize this photo?
Yes, that's the front of the same vehicle with damage to the front windshield.
Third photograph, do you recognize this photo?
Same vehicle, passenger side, both those windows are completely shattered out.
And Is that glass that we're seeing on the ground there?
Yes.
Do you recognize this photograph?
That's a view inside. I think it's the back passenger side window.
Once again, is that glass that's on the seat there?
Yes.
Next photograph, do you recognize this photo?
Yeah, that's the same vehicle, glass on the ground outside of the view.
How about this one?
That'd be the view inside of the front passenger side window with glass on the front seat.
Now, do you recognize this photograph here?
Yeah, it's that, I believe it's in the back seat, passenger side again. Glass on the seat, and then there's a black and orange hammer on the floorboard.
That's the handle for a hammer there?
Yeah.
You recognize that photo as well?
Yes, it's the same seat, same hammer. I just put it up on the seat to present it better for a photo.
You recognize this photograph?
That's the rear of the same vehicle.
And what is this photograph?
That's Sierra Johnson's residence. It was a duplex. Her door's on the right, so that'd be 706 West Saginaw. Unit 1 would be the door on the right there.
Now, how about this photo?
That is the bedroom inside of that unit. Sierra Johnson advised was her bedroom.
Okay. You recognize this photograph?
Yes, that was the TV in that same bedroom. Damage to it.
You recognize this photo?
That's Sierra Johnson.
That's the one we spoke.
Yes.
And how about this one?
That's the back of Sierra's head. At that time, she was showing me her hair because she advised some of her braids had been pulled out during the altercation.
And did you notice if any braids had been?
It appeared that there's some missing from there. There's a spot without any braids, but she wasn't able to show me any loose braids or any that had been removed.
How about this one?
It's just a picture of her neck due to the way she described the assault, but I didn't observe any injuries on her neck.
These still photographs from that night?
Yes.
And is that still Sierra Johnson?
Yes.
Same with this one?
Yes.
That is all of the photographs contained in People's Proposed Exhibit 1. Now, Officer Bush, do these photos accurately depict what you observed that night? At this time, people would seek to move People's Proposed Exhibit 1 into admittance.
Any objections to people exhibit 1?
Objection.
People's 1 is admitted.
Now, Officer Bush, you spoke to Ms. Johnson about the assault, correct?
Yeah.
And without yet getting into detail about what she told you, these things you observed and took photos of seem to match what she told you would happen?
Yes.
Thank you. Your Honor, at this time, people would proceed to go forward with testimony of what Ms. Johnson specifically told Officer Bush under MCL 768.27C. I believe all the necessary elements under that statute have been met. This is an instance of domestic violence where the victim of domestic violence was describing, narrating, or explaining the infliction of physical injury upon her to an officer acting in his capacity close in time to the incident, and there is corroborating evidence to what she told the officer occurred.
Any objection from the defense?
Your Honor, the only part I would object to is evidence relating to the alleged property crimes involving damage to the vehicle and the television. I don't believe that falls within the exception allowed by the statute for narrating domestic violences.
Yes, okay.
Your Honor, the statute is very broad when it comes to that, narrating, explaining, or describing the situation involving the domestic violence. The case law has always held that it is still an ongoing incident in that moment. Same when he's going outside and destroying her property, that's still the incident of domestic violence that she's describing. The incident has not ended. It has not ceased being an incident of domestic violence.
Okay, do MCL 768.27C, section B, it states the action in which the evidence is offered under the section is an offense involving domestic violence. Agree with the interpretation and argument made by the prosecution that it is broad, and so it can serve to narrate continuous action that involves a domestic violence. In this situation, we have allegations of an incident that seems to commingle a property damage domestic violence situation. So for that reason, the objection is overruled and your witness can proceed under 27C.
Thank you, Aaron. Now, Officer Bush, what did Ms. Johnson tell you happened?
She started off by saying, Mr. Wallstander come over to visit the two children that they have in common. And she said everything was fine at first until she told him it was time for him to leave her residence. He started getting angry and throwing and kicking property around inside the residence. And then, so she said she went outside to become separated from him. And then he started telling her she needed to come back in. So she stated she went back inside the residence. And as soon as she came inside, she realized she was dragged from the front door to her bedroom by her hair.
And was that when she was talking about braids?
Yes,
being
she
missing?
said she was pulled by her braids.
That she told you that property was damaged inside. Was that the television that we saw photos of?
Yes, that was part of that. That happened. There was more that happened before that, as far as the physical altercation. If I may elaborate on that some more.
Please, what else did she tell you?
She stated when she was dragged to her bedroom, Mr. Wellstander pushed her onto her bed and got on top of her and placed two hands on her neck and was squeezing her neck to the point where she felt dizzy, and she told me she felt like she was going to die. She stated this action was done by him for approximately 3 to 4 minutes. She thought her kids had gone outside asking passerbys for help because she said 2 men that she didn't know came inside the residence to help her and get Mr. Wellstander off.
So her children were present during this?
Yes.
Do you know if Mr. Wellstander was the father of those children?
She stated that two of their kids were in common, and that's why he was there, was to visit his children.
So 2 men came in to help her. What did she say happened next?
She said they were able to pull him off of her, so she went to grab her phone to begin calling 911. She stated Mr. Wellstander was able to get away from those unknown men and took her phone out of her hand, and she thought that he knew she was trying to call 911 for help at that time.
So to be clear, these 2 random men had just pulled him off of her. He was strangling her, and then she went to get her phone.
Yeah.
And then he took the phone away from her.
Correct.
What did she say happened next?
She advised that she was separate again at some point, and she heard a loud noise from inside her bedroom, which she later discovered that her TV was broken after she heard that noise and that it wasn't broken before. She doesn't know what caused the damage to her TV specific. Other than she thought Swells had damaged it while he was in there.
So he was still in that bedroom when the TV was damaged?
Yes.
So she heard that loud noise. What did she say happened next?
She stated she was trying to stay separate over by the front door, so Mr. Wellstander walked out of the bedroom, went straight to the kitchen and grabbed a hammer out of the kitchen, and they went out opposite doors. She said she went out the front to the porch and he went out the back. She stated by the time she went out the front, he was outside by her vehicle, smashing the windows too.
So she physically saw that. So she sees Mr. Wells Tanner smashing the windows of her car with a hammer. What does she say happens next?
I don't recall exactly what happened next. I remember that was close to the end of the incident. Can't quite remember off the top of my head what caused it to finally end.
We're looking at a copy of your report of refreshing memory.
Yes, so
I may approach you. Honor.
You may, are you finished with this exhibit?
Yes, Your Honor.
Okay, if you want to return my
I'll let Brian figure that out.
post capabilities.
As much as I like being in charge of the court Zoom, I'd rather not do it for that long. And officer, when you have finished reading that to the point where you feel it's sufficiently refreshed your recollection or is going to be impossible to do so, look up, let me know. I'm going to come get that report back from you, ask you the question again. Thank you. Appreciate it.
Thank you.
All set? Yes. Now, Officer Bush, did that sufficiently refresh your recollection?
Yeah.
So, after she sees Mr. Wells Tanner smashing the windows of her car, do you remember what she says happened next?
yeah, I remember now because there wasn't anything else. She said he got in his car and drove away. I just want to make sure I wasn't missing anything.
It's good. Did she tell you what happened to her cell phone?
She said that he still had it in his possession when he left. That's why there was the delay in her calling 911.
She had to actually find a phone.
Yeah, she said she waited for her father to show up and use his phone.
Now, did she tell you the name of the individual who assaulted her?
Yes.
And what was that name?
Greg Jarrell Wilson.
Did she give you a description of this man?
Yes.
And what was that description?
She said he stands approximately 5'9" and about 220 pounds. Said he was wearing all black on the incident. She stated on one of his biceps he had a tattoo of the word pint, P-I-N-T.
Your Honor, at this time, I would ask the court to instruct the defendant to roll up his sleeves in order to see if he has tattoos on those biceps, identifying him as the man that she claims assaulted her.
Your Honor, I object. He's got a right against, my client's got a right against self-incrimination. They could have done this as part of their investigation a long time ago. If they don't have somebody here today who can identify my client, they've got to dismiss this case.
That's not included in the right against self-incrimination. That is a physical attribute that identifies him that he is currently concealing. He is not testifying or incriminating, providing any testimony incriminating himself.
Is it the only description that was given for identification purpose?
She gave full name, height, weight, race, brief description, and then a very specific identifying tattoo.
Did she give a date of birth? Witness.
Yes, she did. I don't recall the date of birth off the top of my head, but I remember she gave it to me and an address in Lansing that he frequented. I don't remember if it was his registered address or not.
Okay, and so is it your position that your witness cannot identify him without him rolling up his sleeve and showing his tattoo?
Correct.
Okay.
There's not anything covered by the Fifth Amendment.
I don't know, this might be an issue that needs to be briefed.
Certainly do that, Your Honor.
Your Honor, the witness obviously has never seen this person before and can't identify him. This case needs to be dismissed. This is too far.
Yeah, I don't feel comfortable with making him take his jacket off and show a description of himself for the purposes of identification. If the argument is that it violates his Fifth Amendment, I think that's an issue that needs to be addressed in a brief. before the court, and I'll make a decision on that after I've had briefs from both parties. So we'll get back to identification. You can continue your questions.
Thank you, Your Honor. Now, Ms. Johnson confirmed for you that the television, the car, the cell phone all belong to her, correct?
Yes.
Did you get damage estimates for this property?
Yes, I did. She told me she had just bought the TV very recently, within a few days. I don't recall the exact number, but I remember it was somewhere around $800. It was a 75-inch TV, and she said she just bought. I don't know the amount of damage that three shattered windows on a vehicle would be, but I imagine probably at least $1,000.
And then what about the cell phone?
I don't recall. I remember she gave me the type of cell phone. I don't recall the market value of such cell phones.
One moment, Your Honor. Not at this time, people have no further questions for Officer Bush.
Cross again.
Yes, thank you. Officer Bush, after this, after your response to this incident, is it true that you typed up a police report?
Yeah.
And that was in accordance with your training and experience?
Yes.
That was meant to be an accurate reflection of what you observed at the scene?
Yes.
And in fact, today you used that same report to refresh your memory, is that correct?
Yes.
And you did not leave anything that you felt would be relevant out of that report, is that correct?
I think that's
So is it true that you did not perform a neighborhood canvass after responding to this incident? You did not obtain any surveillance video of the parking lot?
Wait, let me stop. You say you don't recall doing so?
correct.
So
No,
is that a yes or a no, or I don't remember?
It'd be a no.
Oh, thank you.
Okay, you did not obtain any surveillance video of the parking lot?
No.
You have no further information as to the identity of these other two alleged witnesses?
No, I had no way of identifying them.
You only-
Or locating them.
Sorry for interrupting. Your only description was that they were males, is that correct?
Yes, and she said one of them told her that his first name was Dwayne, but that was all.
And goes without saying, but I'm going to say it for the record, you were not present during any alleged property damage or attacks on the person of the lady who was reporting this incident, is that correct?
Correct.
All right. And you did not locate the 4 braids that she alleged had been ripped from her head, is that correct?
Correct.
You learned as part of your investigation that the intimate relationship between Sierra Johnson and Craig Wells Tanner had ended about 1.5 years before this incident, is that correct?
Yes.
Now, Sierra indicated that she waited for her father to come to the scene to use his phone, is that correct?
Yes.
As part of your investigation, did you learn if these 2 other witnesses had telephones?
No, I didn't know.
Did you come to find who else may have been present in the other unit of the duplex?
No, I did not.
No further questions, Your Honor.
Let me be direct.
No, Your Honor.
Okay, I just have a follow-up question and it's identification. So, Officer Bush, You were given the description, and you didn't do any investigation based on that description at the time to identify who the suspect was?
I don't remember if I ever ran him in any of our report writing systems or in Lean to look up a Secretary of State photo. I might have, but I don't remember doing so. Or looking at it if I did.
Thank you. Any cross-examining based on my question?
Officer Bush, is it standard procedure to run them in the Lien Secretary of State system?
Yes.
And is the reason you don't remember because this was from over 2 years ago?
Yes.
Thank you.
Officer, you told me a minute ago that there's nothing you left out of your report that would be relevant. Is that correct?
Yes.
You did not list in your report any effort to look up a picture of the suspect. Is that correct?
Correct.
No further questions, Your Honor.
Thank you. Minutes for this be excused.
You may, Your Honor.
No objection.
Thank you, Officer Bush. You can call your next witness.
People with rescue, Your Honor.
Okay. Is defense gonna call witnesses today?
No, Your Honor.
Okay, we're going to continue this to allow for the prosecution to file a brief as to their request to have this defendant show his arm as purposes of identification, and whether or not that violates his Fifth Amendment rights. I expect a responsive brief as well from Mr. Pass, okay? And I'm gonna need that in advance of the next court date so that I can read it.
Absolutely, Your Honor. What date would the court be looking for?
We can do next week, April 27th. Wide open.
Yes, is that next?
The 27th,
Yes, is that, I'm sorry, is it Thursday or Friday? Your Honor?
Thursday,
And what time?
9:30.
Okay, thank you very much, Your Honor. I look forward to receiving Mr. Pfeiffer's brief, look forward to responding to it. And my client and I will see you on the 27th at 9:30.
Sounds good. I just need them by the 26th.
Understood, Your Honor. Thank you.
Okay, any additional matters for the record today?
Not from the people, Your Honor.
No, Your Honor. Thank you.
Any questions for today? Okay, we'll get you a copy of your notice to appear and then we'll see you next week, okay, sir?
Yes, ma'am. Thank you. Thank
You're
you.
welcome.
Thank you, Your Honor.
Sorry, this table.
Yeah. It's a little tight.
I kick it a lot.
It's tight in here.
We'll go check